Hello guys, in today's video we'll discuss when can police may arrest without a warrant. This has been provided under section 35 of Bharatiya Nagrik Suraksha Sanhita. Now let's start reading. So any police officer may, without an order from a magistrate and without a warrant, arrest any person who commits in the presence of a police officer a cognizable offence. So this is the first condition where the police officer can arrest any person without an order of a magistrate or without a warrant. So this is the first condition. What is the condition? Condition is a cognizable offense should be committed, and that too in presence of a police officer. So when a cognizable offense is committed in presence of a police officer, the police officer is entitled to arrest that person then and there. What is a cognizable offense? Cognizable offense has been described in section 2 of the BNSS, and a cognizable offense is an offense which is scheduled under Schedule 1 of BNSS, where the police officer can arrest without warrant. So this is the first condition where a police officer can arrest any person without a warrant. Now let's move on to another situation where the police can arrest without a warrant or an order from a magistrate. The second condition is when there is a reasonable complaint or a credible information or a reasonable suspicion against any person who has committed a cognizable offense which is punishable with the imprisonment for a term which may extend to 7 years or which is less than 7 years. If following conditions are satisfied. So, when we talk about the second condition, where the police officer may arrest without an order of a magistrate or a warrant, is that there should be a reasonable complaint or some credible information or a reasonable suspicion that an cognizable offense has been committed, which is punishable for a term which may be extendable to 7 years. It should not be more than 7 years, irrespective of the fact whether punishment includes fine or not. The police officer may arrest such person. So, in the first condition, any cognizable offense which was committed in the presence of the police officer was entitled to arrest that person. In the second condition, we are talking about some complaint or some information or some suspicion regarding the commission of an offense which is cognizable and whose punishment is imprisonment for a term which may extend to 7 years with or without fine, if the following conditions are met. Now, what are those conditions? Number one, the police officer has a reason to believe on the basis of such complaint, information, or suspicion that such person has committed the said offense. So, three things are necessary here. The police officer must have, first of all, reason to believe that the said person has committed that offense. On what basis? On basis of the complaint or the information or the suspicion which is mentioned previously. This is the first condition. Second condition, which is mandatorily required to be met by the police officer, is that the police officer should be satisfied that the such arrest is necessary for what purposes? For these five purposes which are mentioned hereinafter. First, circumstances. The police officer wants to prevent that person from committing any further offense, or that police officer wants to make a proper investigation for that offense. Third, that there is a probability that the evidence in respect to the offense which we are talking in the above clause has a tendency to disappear or being tampered with the said person which is required to be arrested by the police. So in that case also, that person may be arrested without warrant. Subclause D, where there is an apprehension that the said person which is required to be arrested by the police can make any inducement or threat or promise to any other person which is acquainted or well aware with the facts and circumstances of that matter. And there is a probability that that person, that third person which is well acquainted with the facts of that matter, may dissuade that person may dissuade that third person from disclosing the facts to the court or to the police officer. Fifth condition is that the person which is required to be arrested, it is presumed by that officer or observed by the officer that the said person cannot be brought before the court whenever required, or his presence cannot be ensured before the court. So in that person, that condition also, the police may arrest that person without any warrant. Now, this is provided, and he should record the reasons for making the said arrest. So either a cognizable offense has been committed in the presence of the police officer, or a reasonable complaint, credible information, or reasonable suspicion exists that a cognizable offense has been committed, which is punishable up to 7 years with or without fine, if these following conditions are met, which we have discussed right now. So let's talk about the third condition. The third condition is when a credible information is received by the police officer that the said person has committed a cognizable offense, which is punishable with imprisonment for a term which may extend to more than 7 years, with or without fine, or which is punishable with a death sentence, and the police officer has a reason to believe that the said person has committed the said offense, then he can arrest that person. So where there's a credible information that a cognizable offense has been committed, which is punishable with more than 7 years of imprisonment, with or without fine, or with a death sentence, and the police officer has a reason to believe on the basis of that credible information that that person has committed the offense. In that circumstance, the said police officer may arrest that person. Now, let's talk about the fourth condition. Fourth condition is when a person has been designated as a proclaimed offender, has been proclaimed as an offender, or has been declared a proclaimed offender by the state government or under this Sanhita. In that circumstance also, the said person may be arrested without warrant or an order by some magistrate. Now let's talk about the fifth condition where a person can be arrested without a warrant. The fifth condition is when a person is found in possession of what? A stolen property. That person is found in possession of a stolen property. Not necessarily that property may be stolen, but that property should be reasonably suspected to be a stolen property. There should be a reasonable suspicion that that particular property is stolen. In that case, and there is another condition to that. First is that a person is found in a possession of a property, and that property is reasonably suspected to be a stolen property. And third condition is that person is reasonably suspected to committed an offense with respect to that property. In such case also, that person may be arrested without warrant. Sixth condition, whosoever obstructs a police officer when he is exercising or executing his duty, that person may be arrested. Or any person who has escaped or attempts to escape from a lawful custody. Remember, guys, the custody should be lawful. If the custody is lawful and a person is trying to escape from that custody, that person may be arrested. So this subclause is clear. Finally, subclause G, a person who is reasonably suspected to be whom a deserter of any of the armed forces of the Union. So if a person is suspected to be a deserter of an armed force of the Union, then that person may also be arrested without warrant. Now let's move on further. Subclause G, who has been concerned in, or there is a reasonable complaint against that person, or a credible information is there, or a reasonable suspicion is there. Three things are there. Either he is concerned, or there is a reasonable complaint, or there is a credible information, or there is a reasonable suspicion. Regarding what? Regarding an act that was committed out of India, at a place out of India. And if that act would have been committed in India, then it would have been punishable as an offense in that context. And there is a law regarding extradition wherein he is liable to be apprehended or detained in custody in India. In that case also, the said person may be arrested without a warrant. Clause E, who is a released convict. The person who is a released convict, and what he commits a breach of any rule. Which rule? A rule made by the state government under subsection 5 of section 394. So under subclause 5 of section 394 of BNSS, the state government is empowered by notification to make rules regarding the residence of the released convicts. So if a rule is being made by the state government under subsection 5 of section 394 and a released convict commits a breach of that rule, he may be arrested by the police officer without warrant. Now let's consider the last subclause, which states when there is a requisition, that is a request by another police officer regarding the arrest, whether written or oral, to some other police officer, and such requisition or request specifies the person to be arrested and the offense or other cause for which the arrest is to be made. And what is necessary? It is necessary that from the basis of that information which has been provided under the requisition, the police officer which is arresting that person might lawfully arrest without a warrant. So in that context also, an arrest without warrant may be made. Now let's move on further. So these were the conditions on which an arrest may be made without a warrant or without an order by a magistrate. Now let's talk about subclause 2. It provides that subject to the provisions of section 39, no person concerned in a non-cognizable offense or against whom a complaint has been made or credible information has been received or reasonable suspicion exists of having so concerned shall be arrested except under the warrant or order of a magistrate. So, in case a complaint has been received or credible information is there or a reasonable suspicion is there that a person has committed a non-cognizable offense, in that matter or in that case, that person cannot be arrested except under the warrant of a magistrate. One exception is there, which is this condition is subject to the provisions of section 39. So section 39 talks about when a person may be arrested when he is accused of a non-cognizable offense and he refuses, or a police officer has a reason to believe that that person is not disclosing his identity, his name, and his residence. So, subject to this provision, no person accused or against whom a credible information has been received or a reasonable suspicion is there can be arrested without a warrant. Subsection 3. Police officer shall, in all cases where the arrest of a person is not required under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or a credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at any place as may be specified in the notice. So, where a police officer receives a credible information or a complaint or has a reasonable suspicion against any person, and that police officer is of the view that arrest is not required under subclause 1 that we just discussed. So in that case, that police officer may issue a notice directing that person to appear before him at any place which may be specified in that notice. Earlier, this was section 41A. 41A के अंदर नोटिस भेजती थी पुलिस. हालांकि इस सेक्शन के अंदर भी पुलिस अरेस्ट कर लेती है, which will discuss later on. So this is subclause 3. Now let's move on to the subclause 4. Now let's move on to subsection 4 of section 35. Where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. So where such a notice has been issued to any person, then it shall be duty of that person to comply with the terms of the notice which has been issued by the police officer. Subsection 5. Where such person complies and continues to comply with the notice, he shall not be arrested. When the person is complying and continues to comply with the terms of the notice, he shall not be arrested, provided there is an exception. And what is the exception? Even if you comply with the terms of the notice which has been issued by the police officer under subsection 3 of section 35, the police officer may arrest you if he records the reason for the same and if he is of the opinion that you ought to be arrested. So this is subsection 5. Subsection 6. So what happens when a person fails to comply with the terms of the notice? Subsection 6 provides with such a scenario. So if the person fails to comply with the terms of the notice, the police officer may arrest that person. But one condition is necessary for that. This arrest should be subject to the orders which are passed by a competent magistrate or court in this behalf. So, police, if you fail to comply with the conditions mentioned in subclause 6, the police officer may approach the competent court and request him to pass an order regarding your arrest, and in that case, you may be arrested. Subsection 6. So, my apologies, subsection 7. Subclause 7. No arrest shall be made without prior permission of an officer not below the rank of the Deputy Superintendent of Police in case of an offence which is punishable for imprisonment of less than 3 years and such person is infirm or is above 60 years of age. So, if a person is infirm or he is above 60 years of age and the offense which he is concerned with is punishable with an imprisonment which is less than 3 years. So, in that case, that infirm person or that senior citizen cannot be arrested until and unless a prior permission has been received from a superior police officer not below the rank of Deputy Superintendent of Police. So guys, this is section 35 of Bharatiya Nagarik Suraksha Sanhita. Do comment, did you like this video? Like, subscribe and comment and share. Until next time, bye bye. See you.